Welcome back, everyone. Today is going to be the first lecture in which we will be spending time dissecting a very specific type of crime. In this case, we're going to discuss homicide. We're going to explore the differences between first and second-degree murder, felony murder, and various types of manslaughter. We're also going to identify possible punishments for these crimes, and in particular, we're going to spend some time looking at common law punishments when murder was committed. So let's get started. Homicide is different from most crimes as it's very final. There's no taking back the action, there's no ability to make amends with the victim, and often these crimes can be very heinous in nature. But as serious as homicide is, there are some different grades and variations to the legal code that take into account whether the crime has been aggravated or not. This was not always the case. In colonial America, and even in England, where we take our common law from, the governmental structures did not take the circumstances of the crime into account at all. If you killed someone, then you killed someone, and that was it. There was no distinguishing between the types of homicide. They were all the same no matter how you did it. A dead body is a dead body in the eyes of common law, and all types could earn you the death penalty. In this sense, premeditated capital homicide was the same as involuntary or voluntary manslaughter. Today, things are very different, and states recognize the difference between these different types of homicide. But as we've just finished saying, murder was murder, and all types could make you eligible for the death penalty. Under common law, governments were often undisciplined in how the death penalty was actually carried out. When we established our country in the late 1700s, the newly formed United States actually had to outlaw certain methods of execution, and made hanging the preferred method. Up until then, people were executed in a variety of different ways. Our first example of outlawed methods of execution begins with the burning at the stake. The use of death by burning has long been a popular form of execution and was often used to eradicate certain groups of people, such as those with leprosy, homosexuals, Jews, and even slaves who were brought to the colonies and British West Indies in the early 1700s. In addition, we know all about the famous Salem witch hunts, which resulted in the accused being burned at the stake. Even after the United States government outlawed the use of burning at the stake, it was still used by vigilante groups, sometimes during lynching. This is a pretty basic concept. The individual being killed would be tied to a large post in the middle of a square, and then a fire is lit at the feet of the individual in question. This is a slow death and can take a long time to complete. There are actually typically two main causes of death when burning at the stake takes place. First, if the fire is quite large, let's say for instance a number of prisoners were executed at the same time, death can come from carbon monoxide poisoning long before the flames actually caused much harm to the body. If the fire was small, however, the convict would burn for quite some time until death from hypovolemia, which is the loss of blood and or fluids, heat stroke, and simply the thermal decomposition of vital body parts takes place. Either way, it's typically a long, drawn-out process and can take considerable time for the offender to die. Next up, we have a picture of somebody who was being broken on the wheel. This was a very popular method of execution that was used throughout Europe during the Middle Ages and even into the 19th century. The condemned was essentially tied to a large wooden wheel, which you can see in this picture. The wheel was rotated slowly, while the executioner struck down on the limbs with an iron bar or with a hammer, breaking the bones. This was usually done in public places, and the victim's body was left out on the display for people to see. Often, the breaking of bones did not kill the victim, and he would die days later of shock or dehydration. In some instances, the authority handing down the death sentence would request the executioner deliver a mercy blow so that the condemned would die faster and suffer less. Our next example of execution is the method of drawing and quartering. This was actually a multi-step process, but ultimately the condemned would be tied in 4 different directions, and then horses, or sometimes even machines, would pull the body apart. Until 1867, when it was officially abolished, the full punishment for a traitor could include several steps, as I just mentioned. First, he was drawn. That means he's tied to a horse and dragged to the gallows. It was important that a live prisoner be delivered to the hangman, so often the draw was done slow enough not to kill the prisoner outright. Once the prisoner was brought to the executioner, he was typically hanged, but not until he died. Then the prisoner might be disemboweled while he was still alive. He may have had his entrails burned, or he may have even been beheaded. At this point, he would be quartered, which is when the body is dragged in 4 different directions, as we said. Remember, some prisoners were not beheaded and were still alive when they were quartered, which sounds particularly nasty when you think about it that way. Finally, we have to discuss the rack as our last outlawed method of execution. The rack is a torture device consisting of a rectangular, usually wooden frame, which slightly was raised from the ground with a roller at one or both ends. The victim's ankles are fastened to one roller, and the wrists are chained to another. As the interrogation progresses, a handle or a ratchet attached to a large roller are used very gradually stepwise to increase the tension on the chains. This often resulted in very excruciating pain. By means of pulleys and levers, the roller could then be rotated on its own axis, thus straining the ropes until the sufferer's joints were often dislocated and eventually separated. Additionally, if the muscle fibers are stretched excessively, they're going to lose their ability to contract, rendering them completely ineffective. One gruesome aspect of being stretched too far on the rack is the loud popping noises made by snapping cartilage, ligaments, or bones. One powerful method for putting pressure upon prisoners was to force them to watch somebody else be subjected to the rack first. Confining the prisoner on the rack enabled further tortures to be simultaneously applied. Typically, this included burning the flanks with hot torches or candles, or using pincers made with specially roughened tips to tear out the nails of the fingers or of the toes of the prisoner. After hearing about all these different methods of execution, and even witnessing some of them, you can see why the newly formed United States made sure to outlaw them and expressly chose not to sanction anything besides firing squads and hangings as the official methods of execution for the country. But times have changed, and we've moved away from hanging to what some consider more advanced forms of execution. We have also moved away from a blanket concept of murder. Now we have finite categories of action and behavior when it comes to killing, and not everything is even death penalty eligible anymore. We're going to talk more about the death penalty as a form of punishment when we discuss first-degree murder. When we talk about murder, there has to be some sort of intent. Just like all of our other crimes, there has to be intent to kill somebody else. Intent is demonstrated by what we call malice aforethought. This is us leaning towards premeditation, meaning that I have a plan, I have specific intent, I mean to kill you, and it's demonstrated by my actions to complete that kill. Malice aforethought is the beginnings of premeditation and points us in the direction of a first-degree or capital murder type of crime. Even if malice aforethought isn't there, prosecutors can still look at the behaviors that led up to the killing. Manslaughter can be prosecuted under strict liability statutes. But when we talk about homicide, there normally is that intent to kill, with murder being the ultimate goal. So let's take a more in-depth look at the actus reus and mens rea of criminal homicide. With the actus reus, we know that this is the physical act that I have committed which has resulted in your death. So the actual murder that occurs here. But this doesn't even have to involve me touching you or shooting you or doing something physical to you to cause your death. The textbook gives a really good example of me threatening a woman and telling her to jump in the creek. But she's not a good swimmer and actually dies because of the river's strong current and her inability to swim. The threats that I made against her fulfill the requirements of cause and resulted in her death. The mens rea, or the intent, requires that I knowingly, recklessly, or negligently cause the death of another person. This means that I either need to directly plan the death, my behavior was dangerous and could result in the death of another, or I don't do anything to protect or care for another person, and that person dies as a result of my neglect. Based on the intent and the way that the person has died will influence the way that you are actually charged. we're going to begin dissecting the different degrees of homicide, starting with the most severe, first-degree murder. First-degree or capital murder is considered the worst form of murder possible. Different states will call it different things, but for the most part, this is the one that's going to get you the death penalty. There are two requirements for first-degree murder: planning and carrying out that plan. Premeditation is considered the planning part of the crime. Legal statutes do not require that the plan be long and drawn out, or that I have to plan for a considerable length of time. I might think about the murder for a split second, see the victim in front of me, go get a firearm from the bedroom, and shoot you in the kitchen. That could be the extent of my plan, but it's enough to fulfill the requirements for premeditation. Deliberation, on the other hand, requires that the offender be in a cool state of mind when the murder occurs. If the offender was provoked, was angry, majorly emotional, or was in some other state that was triggered by a situation, then they would not be guilty of first-degree murder. Voluntary manslaughter charges exist for those crimes that are not committed in a cool state of mind. First-degree murder can occur without making the crime death penalty eligible. Nearly everyone requires that first-degree murder be aggravated in order to qualify it for the death penalty. An aggravating factor is really anything that is going to increase the severity of the crime. In order for you to have your crime be death penalty eligible, you have to have at least one of these aggravating factors be present. That was part of the CRIJ decision that was handed down in 1976. So I cannot receive the death penalty simply for killing someone. It has to be something that is aggravated in nature, but juries also have to look at potential mitigating factors before they can make their decision. So for example, who was it that I actually killed? Was it somebody in a position of authority, like a police officer? A politician, maybe? Were there multiple victims rather than me just killing one person? We also have to look at who I am. Is this my first offense? Am I a revolving door offender who has violent felonies prior to this murder? Do I have mental health issues? Or am I someone who killed in a clear state of mind? These might be aggravating or mitigating factors depending on the certain circumstances. What all did the murder entail? Was it something as serious as a murder for hire plot or an act of terrorism? Perhaps I simply planned the murder to take place because I knew that you were cheating on me for years. Or perhaps I killed you in your sleep because you had been abusive towards me for years. It does not have to be as extreme as an act of terrorism, but that certainly does fit within the criteria that is needed here. Finally, a lot of aggravated first-degree murder charges stem from what we call felony murders. For instance, let's say that I went in to rob a liquor store. That's a felony. During the commission of committing that felony, the store manager tried to fight back, and I shot and killed him. Because I killed during that commission of the felony, state statutes consider that to be an aggravated factor that increased the severity of my crime. If one or more of these aggravating factors apply to the first-degree murder case in question, then the aggravating factors make the offender eligible for the death penalty in states where the death penalty is still legal. With second-degree murder, we see some differences popping up that weren't there for first-degree murder. First, there's not going to be any premeditation like we saw with first-degree murder. There's no plan in place to complete the killing. Instead, we still see that there has to be intent to harm somebody, but maybe not kill them. I know that my behavior can result in your death, but that's not my original goal. My original goal is just to inflict harm or cause damage that is dangerous in nature. For example, what if I were to commit arson knowing that there might be still people in the building? I may not want anybody to die, but I just lit an apartment building on fire and I know that there are residents who might be at home in that building. Or what if I happen to be a drug dealer and I sold you heroin knowing that you've never tried it before? I sold it to you, you use it in front of me, and almost immediately you overdose and I don't do anything to help you. Then I would be guilty of second-degree murder. Finally, in one of the most common scenarios we see involving second-degree murder, focuses on child abuse. Many parents end up abusing their children for so long that they sometimes end up dying. The parent may not have ever intended for their child to die, but if you are abusing your child so strongly for such a prolonged period of time that it's clearly a dangerous action that could result in the death of your child. So remember, even if the original intention was not to kill someone, you can still be liable for murder if your actions were dangerous and resulted in serious physical injury. Next, we have to turn our attention to felony murder. Remember, we just discussed felony murder when we talked about first-degree murder. But we have to figure out the components of felony murder and who can be charged when it actually occurs. First, as a review, felony murder occurs when I commit a felony. Typically, they're dangerous and forcible felonies. When I'm committing that felony, then a murder occurs, whether I intended for it to happen or not. It does not matter if the killing occurred with deliberation and premeditation, intentionally, recklessly, or even negligently. As long as that killing happened, I am responsible for it. The other issue we need to address is who actually did the killing. If I am the one who pulled the trigger, then there's no question. It's my fault and I am criminally liable. But what if my co-conspirator is the one who pulled the trigger, or somebody else entirely? Under the agency theory, it doesn't matter who kills the victim, you are still responsible. If you were there and were part of the original felony, then you are criminally liable for that crime. Always look for the words "but for." But for this felony, the murder would not have happened. This one only applies to those who are involved in the crime and not any bystanders who might intervene. Under proximate cause theory, anyone could be the cause of the murder, and you would be liable as somebody who was originally part of the felony. This means that an innocent bystander or even the original victim could potentially be the one to kill someone, and you are responsible because of the felony's role in the murder because it was a foreseeable result. But in this one, it doesn't matter who does the killing, you are still responsible 100% for everything that goes down. For example, if you rob a liquor store and the store attendant shoots the people trying to rob him and one of those people die, the individuals responsible for the robbery are now responsible for the death, not the store attendant, because it is reasonable that the attendant would react the way he did and try to defend himself and the store that he manages. The store attendant is not at fault since he was not the original victim. Finally, we have to discuss voluntary and involuntary manslaughter. With voluntary manslaughter, there's not enough time to formulate a plan or to have any sort of premeditation that comes into play. This is a reaction that comes from a situation that you have just encountered. This one needs adequate provocation. Okay, so what does adequate provocation mean then? Mostly when we speak of adequate provocation, we mean crimes that are being committed within the heat of passion. So let's use the classic example of a wife who finds her husband in bed with another woman and she goes crazy. She takes a gun out of the nightstand and she shoots both of the people in the bed, killing them instantly. She did not intend to find these two individuals in their bed, and she did not intend to kill them. But circumstances happened as they did, and she killed them as a reaction to the anger that she felt. She was not in a cool frame of mind. We see this happen with adulterous situations, in circumstances with aggravated assault or battery, or when mutual combat occurs and things escalate into a death. The important part to voluntary manslaughter is the heat of passion issue. If there is any time to cool off, and you take that time to cool off, and then you came back, the murder is no longer voluntary manslaughter and can be increased in the level of homicide that you are charged with. For example, let's take that same wife. If she were to run out of bullets, let's say she left the room, she reloaded the gun, she came back into the room and started firing again, then this has the potential to be first-degree murder to premeditation suddenly kicking in. Finally, we have involuntary manslaughter, which is divided into two categories of negligent and misdemeanor types of manslaughter. Some states include vehicular manslaughter within involuntary manslaughter statutes, and others keep them entirely separate. But either way, we should explore what all is included in the different subcategories. First, we have negligent manslaughter. This really means that I have done something that can cause serious injury or death of another person. It also means that I have failed to act, and that failure resulted in your death. For example, let's say we all have elderly relatives who probably need some extra care at some point in their lives. What if you are the primary caregiver, and you decided that it was too expensive to keep feeding or providing medicine to that relative? And as a result, you knew that by withholding food or medicine from that person, there was a high likelihood that they would die as a result. If you still did it anyway, and Grandpa then dies, you would be criminally liable for negligent manslaughter. Misdemeanor manslaughter results from the unintentional killing of an act, or from an act rather, that is unlawful, but is still not a felony. So before, we had the example of felony murder where you had to commit a felony first. Here, you only have to commit a misdemeanor. So instead of robbery, which is a felony because it's a dangerous crime, obviously, let's say you have elected to commit petty larceny, which is a misdemeanor due to the amount of money that the item you stole was valued at. During that larceny, the victim startles you or you try to defend the property, and you take out a gun and you shoot them. This would be an example of misdemeanor manslaughter. The intent was to commit the larceny, which is the misdemeanor, but instead you ended up killing someone. Misdemeanor manslaughter has been abolished from a lot of states and is very rarely used, but can still be an option for some in terms of prosecution. Finally, we have vehicular manslaughter. You are probably most familiar with this type of crime. As we said before, it is a more specific variation of involuntary manslaughter, but really it just depends on the state and how they choose to prosecute you. But basically, you have killed someone with your car after you have driven dangerously or recklessly. It does not always have to involve alcohol. You could have just been speeding way too fast and hit another car, killing the person inside of it. Or you could have been under the influence of alcohol or another illicit substance. Either way, you were intoxicated and you killed someone as a result. It is considered involuntary manslaughter because you were not able to form the mens rea to kill someone, especially when intoxication is involved. Yes, you may have been voluntarily using the substance or voluntarily drinking the alcohol, but voluntary intoxication leads to involuntary crimes. That really brings us to the end of today's lecture. We have covered first and second degree murder, felony murder, and voluntary and involuntary manslaughter, as well as their related punishments. Remember that not all cases of murder are the same, and we no longer treat them the same way we did during colonial America and when we operated largely under English common law. Just as our way of prosecuting crimes has changed, so has our uses and methods of execution, as we saw when we discussed the death penalty earlier. Next time, we're going to explore sex crimes and other types of personal crimes. Meet me back here next time as we delve into Chapter 8 of the textbook.